We want to have a debate over the Patriot Act because we're concerned about our liberties. We're all concerned about terrorism too, but we don't think you have to give up your liberties in order to combat terrorism. On February 15th, we extended the Patriot Act for 90 days. During that period of time, and on the Senate floor on February 15th, we were promised a week of debate, and we were promised an open amendment process. We are now amidst a process where we will have no debate and no amendments. Do we fear terrorism so much that we will not have debate? Do we fear terrorism so much that we throw out our Constitution and are unwilling and afraid to debate our Constitution? I think that's a sad day, that we can't come down. Our senators are afraid to vote on the issues of the day, afraid to debate the Constitution, afraid to have an open forum and debate whether or not the Patriot Act is constitutional. I think this does a great disservice to the voters. They talk about this being the world's most deliberative body. We're unwilling to deliberate. We're unwilling to have questions and have questions broached as to whether or not the Patriot Act is unconstitutional. We've been in session 99 days since then. We've had 99 days since we've extended it, 43 days in session, and we've had 56 votes. What does that mean in the context of things? We are setting a record for the least amount of votes ever to occur in the Senate. There are some important questions we should be debating, but unless it's a foregone conclusion, unless they've counted the votes and decided the outcome before we have the debate, we are precluded from debating. Wendell Phillips, the great abolitionist, wrote, "Eternal vigilance is the price of liberty." The Patriot Act is a perfect example of how a lack of vigilance leads to loss of liberty. In the aftermath of 9/11, we amended the Constitution with the Patriot Act. And you say, whoa, we didn't have an amendment to the Constitution, did we? Well, we didn't do it the way we're supposed to, but we did in reality amend the Constitution with the Patriot Act. How did this happen? We were fearful, and 9/11 had happened, and we wanted to stop terrorism. All of us want that. But do we have to give up our constitutional liberties in order to do that? How did the Patriot Act change? How did the Patriot Act change? How did the Patriot Act change the Constitution? How did the Patriot Act change the Fourth Amendment? Well, we have in the Fourth Amendment, it says that the right of the people are to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place and the persons to be seized. Well, the Patriot Act changed this. The Patriot Act changed the standard from probable cause, which is a long-standing tradition and a standard within the courts, which limits the police from coming into your house unless there's probable cause that you've either committed a crime or in the act of committing a crime. Well, we changed this to a standard we call now relevance. But that's changing the Constitution. How do you change the Constitution? By majority vote. It's supposed to be a supermajority in both bodies. Then it's supposed to go back and be ratified by 3/4 of the states. It's supposed to be difficult to change the Constitution, difficult to amend the Constitution. Why? Because we thought some of these rights were so important that we should not allow a majority to change them. Those of us who own guns and believe in gun ownership think that the Second Amendment is protected from a simple majority taking away the Second Amendment. Likewise, the First Amendment, those of us who prize the ability of the press to print and to respond and to hold beliefs, however unpopular, those of us who wish to have a country in which religion is not hampered and we can say what we believe and not have it hampered by the government, we don't believe that a majority should take away these rights. But a majority did take away part of the Fourth Amendment because we changed the standard of the Fourth Amendment from probable cause to relevance. So if they want to look at your records, they just have to say that it is relevant. They don't have to say you're a terrorist. They don't have to say you're a foreigner. They don't have to say you're conspiring with anyone. They just have to say they've got some interest in your library records. Now, how often is this going on? There's something called suspicious activity reports. Some of this was started before the Patriot Act, some of it's separate from the Patriot Act, but much of it was emboldened by the Patriot Act. The suspicious activity reports are where your bank spies on you. You may not know this is happening. You may not even know if they've spied on you, and they probably won't tell you. But if you've made a transaction that occurs that involves more than $5,000, you could well have been spied on by your bank and reported to the government. Some people say, well, I'm not doing anything wrong. I don't care if they look at my records. Well, here's the thing. If you look at my visa bill, you can tell what doctors I go to. If I see a psychiatrist and I don't want everybody to know it, that may be on my visa bill these days. What magazines I read is on my visa bill. What books I order from Amazon or other booksellers on the internet. Whether I drink alcohol, whether I gamble. There's a lot about your life that is involved in your financial records, and I think they do deserve protection, and that we do deserve a standard where we don't just say, well, it might be relevant, or we might just want to troll through all these records to see if anybody might be committing a crime. This one's even worse than many of the other aspects because the suspicious activity reports do not begin with the government asking any questions. They tell your bank to watch you. Your bank is to watch you and to watch all of your transactions and to report to the government. So they have forms, and you say, well, maybe they're only reporting terrorists. Since 2001, since 9/11, 8 million suspicious activity reports. 8 million have been filed. Over 1 million of these are filed a year. The thing is you could well ask for a Freedom of Information inquiry and ask whether or not you've been investigated by your government for your transactions. My point is that this is an invasion of your privacy. It doesn't have any judicial restraint upon it. And the other thing is that it may not even be good for finding terrorists. It may be that they're getting so much information that they can't even read or listen to all the information. And it's kind of like what they're doing to you at the airports. Because they insist that everybody be searched and everybody be patted down, we're patting down 6-year-olds. A little girl in my town, her dad is a physician and practiced with me at my same practice, was patted down where they're putting their hands inside her pants. I mean, this is absurd. 6-year-old girls. The thing is that by doing that, they're wasting time on people who will not be attacking us and spending less time on people who might be attacking us. The same with your banking records. If they're looking at your banking records, they're not having time to spend looking at the records of people who would possibly be attacking us. 8 million records have been looked at. No judge's order, no judicial review. This one isn't even reviewed by anybody in government. They are giving carte blanche, this power to banks, and they're telling the banks, if you do not spy on your customer, you will be fined. They estimate that $7 billion a year is spent by banks complying with this order to spy on their customers. The thing is we're having trouble in our economy. The banks are struggling. Our economy is struggling. We're having trouble with jobs. And yet we're going to add $7 billion of cost to the banks to spy on their customers. Now, might there be an occasion that a bank transfer or a bank activity could be a terrorist activity? Yes, and if we're investigating those, let's ask for a warrant. And you say, oh, that'll be too slow, we'll never get it. Well, guess what? Warrants are almost never denied. There's a special court set up for the investigation of intelligence. It's called the FISA court. It's been around since the 1970s. Before the Patriot Act, the FISA court never turned down a warrant. And you say, well, these people are awful. We just have to get them off the street. Doesn't matter. I won't any restraint. I just want it done. Unfortunately, that's been the attitude of the majority of the people up here and the majority of Americans after 9/11. People were so frightened, they said, do anything, I don't care. The problem with that attitude is even if you want to argue that it hasn't been abused yet, what happens when people are elected to your government who decide they don't like your religion? Or you believe in a certain kind of marriage and you want to say this, but they want to investigate you. Now there's no step to stop that. There's no step to say, well, your church believes in this unorthodox belief or this belief that we don't call politically correct or it's no longer acceptable. but we want to investigate the banking records of the church and see if we can take away their IRS number or their tax exemption. If you don't have any restraint to these activities, someday we will get a government who has no restraint and then goes forward to say, we want to get that church shut down because that church is saying something we disagree with, or these people are reading these books that we don't like. This goes across party aisle. You look at people, the Library Association is concerned with this also, that people's books are being looked at. Think about it. Do you want the government to know what books you read? Do you want to be on a list, a watch list, because of the books you read? Now they say, oh, there are provisions, and we've made provisions that won't happen. The only way you have a real provision or protection is if you have procedural steps that say, someone must review this before it happens. If we have someone who we really think is terrible and they need to be off the streets, if they are someone accused of rape, accused of murder, accused of robbery, accused of the most heinous crimes we can think of, and it's 2 in the morning, we call a judge and we get a warrant. It's almost never turned down, but it is one step removed from the police breaking down every door they suspect and not having any kind of discussion with someone who has a level head who's not part of the investigation. Now, many up here will say, you know, we're in grave danger. If the Patriot Act expires, all things could happen and terrorism could break loose. What they're arguing, though, is they're arguing that there is a scenario where we wouldn't get warrants to invest terrorism. That never existed. Before the Patriot Act, we were not turning down these warrants. Some have argued that Moussaoui was the 19th hijacker. He was captured a month in advance of 9/11. And many have said if we only had the Patriot Act, we would have gotten him. That's untrue. There is a provision called the Lone Wolf provision in the Patriot Act, but we didn't get Moussaoui because we didn't do our job. We didn't communicate well, and the superiors to the officers and the FBI and the agents in the field did not even ask for a warrant. They turned down the request for a warrant without even asking the FISA court for it. So we have the 19th hijacker a month in advance. We have his computer. When we do look at his computer on 9/12, we link very quickly within a matter of hours to all the other hijackers. Now, it's easy in hindsight to say we could have stopped 9/11, but to tell you the truth, we have to look at the rules and say, could we possibly have gotten that information? The answer is yes. The FBI agent in Minnesota wrote 70 letters to his superiors. The FBI was told that Moussaoui was possibly an agent of terrorism. The French government confirmed it. That was all we needed, and with that information, had they gone to the FISA court, they would have gotten a warrant. When the 9/11 Commission report came out, they acknowledged as much. Moussaoui's warrant would, in all likelihood, not have been turned down, and there's a possibility we might have stopped it. The suspicious activity reports are particularly galling because they are businesses who are forced to spy on their citizens. There's another form of spying that goes on as well, and these are called national security letters. These are like warrants. They go after your banking records, like the suspicious activity reports, but they're a little more targeted in the sense that the government asks for an NSL, but it's not a judge that asks for an NSL. The person who asks for an NSL is an FBI agent, essentially a type of a police or law enforcement agent. The danger here is we've removed the step where the police officer or the FBI agent would then ask for permission from a judge. That's my problem with these national security letters. And some would say, oh, well, we're not doing that many of them. Well, initially we weren't. Now we've done over 200,000 national security letters. One of my reforms, if it were to take place, would be to ask judges to review these. I see no reason why they shouldn't review them. Now, some have said, well, you have no expectation of privacy. The courts have already ruled that you have no expectation of privacy in your papers or electronic records. This is the way it's been interpreted, but I think it's been misinterpreted. I think it's been interpreted that your banking records do not deserve privacy when they're not in your house, and I think that's an incorrect interpretation of the Fourth Amendment. The Fourth Amendment says that in your papers you are to be protected. It doesn't specify whether those papers are in your possession or in someone else's.